How do you put your home into your trust? In today's video, I'm going to break down the actual steps you need to take, from the type of deed you need to prepare, how it affects your mortgage, what about your insurance, and do you even need to do this? I'm Matt Sorensen. Let's build wealth. Now, the home is one of the #1 assets Americans have equity and value in, and it's one of those things that will have to go through probate court if your home is not in your trust. Now, we're talking about your revocable living trust that's part of your estate plan. This is in addition to powers of attorneys and wills that you might have that are part of your overall estate plan. But the main thing that you have in a well-coordinated estate plan is your trust. And the #1 asset you need to make sure is in there is your home. Now, if you don't have a trust or don't understand what I'm talking about here, go back to this video where I talk about how your trust should own everything. In short, if you have more than $500,000 of assets and you own a home, you need to have a trust. A will is not going to cut it. All right, so how do I get the home into the trust? The first thing you need to know is this happens by a deed transfer. You are going to transfer title out of your personal name. Let's say Matt Sorensen is on the deed, or Matt Sorensen and his wife are on the deed, husband and wife. That is going to be transferred over to the trust. And maybe your trust is the Sorensen Family Trust or the XYZ Holdings Trust, whatever it might be. But that is going to be deeded out of your name into the name of your trust. Now, there's different types of deeds used when you're transferring title. There's quit claim deeds and there's warranty deeds. I want to make sure you do a warranty deed. There's a critical reason why you need to do a warranty deed and not a quit claim deed. When you transfer title via a warranty deed, the title insurance you got when you bought the home in the first place stays on the property. Title insurance is this weird insurance policy that you get when you buy a home that says, hey, this insurance policy guarantees you, owner on this deed, that you really own the property. If there's any liens or defects in title, the title insurance company covers that. But when you do a quit claim deed and you deed from your name to your trust, you lose the title insurance protections. However, if you do a warranty deed, deeding from your name over to the trust, you will keep the title insurance protections. So we want to make sure we're doing a warranty deed. In some states like California, it's called a grant deed, but in most states, they're going to call it a warranty deed. So make sure that's the deed form that you're using, and take caution if you're doing a quit claim deed. It can still work, and some people still do a quit claim deed. If I'm choosing, I'm doing a warranty deed. Now, what about if you have a mortgage on the property? A lot of people ask, well, is my mortgage going to be due? Do I got to pay off the loan or something, or work with the bank to make sure I get their approval? You don't need to worry about any of that. When you transfer title to your own trust for estate planning purposes, there is a federal law called Garn-St. Germain. It's the Garn-St. Germain Act that says a bank cannot enforce what's called the due on sale clause. Every mortgage has something in it called the due on sale clause that says when you transfer title out of your name to someone else, you have to pay off the mortgage. However, this federal law says when you transfer title from your name to a trust where you are still the beneficiary of the trust for estate planning, the due on sale clause does not apply. So don't worry about the due on sale clause. You don't have to notify your mortgage company, and the mortgage is not going to be due. Now, the next consideration applies in some states that have a transfer tax or a deed conveyance tax. Some states will charge this where it's a percent of the value of the property. Now, the states that do charge this, for example, Florida, have an exception built into it when you are transferring out of your name to a trust where you are still the beneficiary. So make sure when you're doing one of those deed transfers, you don't get stuck paying the tax. Now, when you're in one of those states, there's a worksheet, kind of a cover letter that you fill out that the county has that says, hey, I'm transferring this to my trust. Don't assess me this conveyance tax. So just know if you're in a state with a conveyance tax or a transfer tax for real property that you're completing the exemption or properly specifying in the deed itself that's exempt. Different counties in different states have some rules on this. Just want to flag it for you here to make sure you don't get stuck paying a tax you don't have to. All right, now who prepares this deed for you? This is not something you want to do on your own. You want to make sure it's done right. The first place is if you did a trust, the law firm that did your trust should help you with the deed transfer. You're going to pay them a couple $100 typically to do the actual deed transfer to make sure the property is transferred out of your name into the trust. If you don't get the property into the trust itself, all the terms in the trust don't help you. Okay, you have to fund the trust and get your assets into the trust. And for your home, that means getting this deed transfer completed. So have your lawyer prepare this. If you had a lawyer, prepare your trust. Now, if you did the trust on your own or you don't want to work with the lawyer for whatever reason, you can work with a title company, and sometimes they're actually cheaper. So the title escrow company, maybe just use the same one that closed the property when you bought it in the first place. Go back to them. They'll already have your file. They'll already know the property and the legal description. They can prepare a new deed transferring title from your name name into the trust. And that might cost you, again, a couple $100 in fees to get the deed done. And then they, of course, handle the recording for you, as would the lawyer that would help in preparing and getting the deed filed as well. And that's a key part here, by the way, is you need to have the deed recorded and approved by the county where your home is located. Now, if you need to get your trust set up and you need your estate plan completed, my law firm, KQS Lawyers, would love to help get that set up for you. And then we will also take care of getting your home deeded into the trust. I hope this video has helped you understand how to get the #1 asset Americans have built up equity and wealth, their home, into their trust. Now, please make sure to subscribe to my channel. I've got a lot of tips on protecting your assets, saving taxes, and building wealth. I'm Matt Sorensen. We'll see you next time.